I'm one of the family law attorneys here at Udall Shumway. When you commence a family law action, whether it be a dissolution, a legal separation, or even a post-decree matter, you'll need to consider how you're going to serve the initiating paperwork to the other party. The formal way of doing this is by hiring either a private process server or asking a sheriff's deputy to do that for you. They would then take the paperwork to your spouse or former partner and deliver that material to them, and that will create the record of having been served and initiating the action. Another way of doing it, particularly when the parties are amicable and there's not a lot of drama between them, or perhaps something that you're initiating is actually expected, is to have the other party sign something called an acceptance of service. That document is a piece of paper that's signed by the responding party in front of a notary public that says, I have received the documents. It's not even necessarily saying that they agree with anything or anything of that nature. They're just acknowledging that they have received the documents. That acceptance of service would then be filed with the court, again, to prove that service has occurred and the action can commence. Another way of effectuating service is to send the initiating paperwork, a petition or other such material, to the responding party through the certified mail system. That's that system with a green card typically, and that other party will have to sign that card. Now, if that party lives with someone else, a new spouse or a friend or roommate of something or something of that nature, and that spouse or friend actually picks up the mail, if they sign it, service is not effective. The responding party has to be the person that signs that card. And that card would then again be filed with the court to prove service has actually happened. If you have any trouble finding the responding party, perhaps there's been a long period where you haven't spoken with each other, or the party has simply up and left and you don't know where they've gone to, you have other options in terms of how to get that person served. The court generally will allow you to file by public or serve by publication when you can prove to the court that you have undergone sufficient efforts to find that person, such as reaching out at any last known contact numbers or email addresses, potentially asking any mutual friends or family, potentially now doing Facebook searches, Google searches, things of that nature. So if you can prove sufficiently that you've exhausted all your efforts, you can serve by what's called publication. If any of these methods aren't going to work for you, there are ways to ask for alternative service. Before you engage in any kind of request for alternative service, I'd highly recommend that you speak with a family law attorney to find out what your options may be and if you have exhausted all your other options first.